Alrighty. Trent, are you guys seeing the syllabus in the chat?
Yeah, I see the syllabus.
Alrighty. I'm trying to drop the PowerPoint because I'm having a problem opening the PowerPoint in my chat. So I'm trying to drop it here. If you don't mind probably sharing it from your end, that would be most appreciated. Coming, give me a second, guys. Give me a second. I'm having a little difficulty because I was really hoping that we were just going to go through past papers, but here we are. But that's fine. Trent. And can you check your chat? You see it? All right, can you share for me? Let me drop it in Dan's chat. I don't know about you guys, but for me, I like to see things when I'm learning. So that's why I'm trying to get this PowerPoint up for you so that we can just go through it together. I can explain, but you can actually see what is being explained. I don't know why I'm having a problem opening this thingy. Oh, Lord. Oh, sorry. My apologies. Can you share now? Alrighty. So, what is a mortgage? A mortgage is a conveyance of land or an assignment of chattels as security for the payment of a debt or the discharge of some other obligation which it is given. A conveyance of land or an assignment of chattels as security for the payment of a debt or the discharge of some other obligation for which it is given. Anybody understands what that meaning is saying? Anybody understand what exactly that is saying? Alrighty.
Miss, is it saying that you're also
You're breaking up. My apologies. I'm not hearing you well.
Oh, it's
Jada, Tishay, what exactly is
Right.
your
So
understanding?
I understand that it's basically saying that your house or your land is gonna serve the role as a collateral, and whatever financial institution you borrow the money from is gonna take back your home as a collateral in the event that you cannot pay the debt.
Okay,
I could just step in at this point.
go ahead.
A definition on a CAPE exam, I would recommend not to use any specific type of property because in essence, you could mortgage anything. So you could mortgage furniture, you could mortgage a car, you could mortgage anything. So try not to say specifically a house or land because although that's what most persons mortgage, especially when they go through the bank or the financial institution, still try to keep it general. So use the word property. So basically, a mortgage is a conveyance of an interest in property to secure payment of money for something, to be used for something. You don't have to say something, but of course, I would expect that you all have your own definitions at this point. But try not to give specific examples in your definition. So if you wish to give an example after giving that definition, you could, of course, say, for example, this is when you convey land, well, not convey, convey is to sell, but really this is when you give land or a house to the bank, and it's not definitely giving it to them, but it's as security. So they don't own it, you still own it. But in the event that you fault on your mortgage payments, then they will own that particular asset or property. So I hope everyone was able to understand that. So try not to use specific examples in your definitions, but use them in an example or something else. So to me, I think that all of you have the idea of what a mortgage is. But what normally tricks persons up is what is the difference between a mortgagee and a mortgagor. I think once you could understand that, then you have a good grasp of the entire topic. So who could tell me what is a mortgagee and what is a mortgagor? Ignore what you just saw. I'm still waiting for the definition of a mortgagor and mortgagee.
The mortgagee is the lender and the mortgagor is the borrower.
Okay, no. Someone else give me the definition of a mortgagor and mortgagee, but that's a good attempt though.
Guys, all right, what I need you guys to get is that in order to be brilliant law students, you have to get over this fear of talking. Law is something that requires you to express yourself. You have to talk in order for you to understand. It doesn't just cement in your heads like that. It requires you to talk out loud so that we can know if you guys are on the right path, because not everybody is going to just get it by just reading. It requires that you guys have a conversation. It's going to be pointless if it is that you guys think that we're going to be here to lecture you guys. It is not a lecturing session, it's a revision session. That means that you guys would have already have studied for the topic or studied for the topics, and you guys are now here to get clarity on things that you guys don't understand. But we have to know what you're not understanding in order to provide any sort of clarity. Go ahead, Akil. I hope that's your name, how your name is pronounced. But Foster.
Yes, okay. So the mortgagor is typically the owner of the property, while the mortgagee would be the financial institution that would be facilitating the mortgage, so to speak.
Hey, Huggins, could you mute your mic, please? Friends,
Yes.
wanna-
So I don't know if that was Akil who gave the definitions, but you're on the right path. So the mortgagor is the person who owns the property. The person who is going to the bank or other financial institution to say, this is my asset, this is my property, and I'm giving it to you for something in return. And you were correct also with the mortgagee definition, that is any financial institution. You don't have to say a bank, but a bank would be the best example. That's the most common type of mortgagee. So the mortgagor is the person who owns the asset or has an interest rather in property, and the mortgagee is the person or institution who is lending money to someone else. So I hope everyone got that. And if you ever forget which one, just try to, well, I'm assuming that you guys know the definition of an offeror and offeree on the contract law. I hope my assumptions serve me right, but it's basically the other way around. So the offeror is the person who makes the offer to the other person, similar to the mortgagor, because then they go into the bank requesting money, because the bank don't go to people and say, hey, I want your property, here's some money. So the offeror is the mortgagor going to the bank or institution to request money, and the offeree is the person who is offering some type of assistance. Could be money, could be something else, but it's usually a loan of money. Right. So you're all good with that, I think. If anybody still doesn't understand, you could just raise your hand.
Akil, is that an old hand or okay? If you guys would like to take a picture of this, there's no copyright on it yet. But you guys have permission to take pictures and make notations and stuff like that. I don't know if you guys study by using cue cards, but you guys can jot down some things. It's important to know the case, even though Trent could probably correct me if I'm wrong, or you guys could correct me because you guys already did unit 1. Do they still require you guys? Are you guys using a lot of cases, or you guys just using definitions with not really a lot of backative?
It's more so cases, and not all of us have done unit 1 for law.
Oh,
There's
my
a
apologies.
challenge too.
My apologies. Okay. The only reason you see this case being presented here is because we are taught to always back our definitions by using a case. And this definition actually came from a case, right? So you guys are free to take it down, and you guys are free to also look at the case, probably the facts or the judgment, to see exactly the ruling and how exactly that came about. So we're moving on, Trenty. So what is a mortgage? Another definition of mortgage is a security for the repayment of money lent. The mortgagee obtains rights over the property of the mortgager. Both registered and unregistered land may be mortgaged. Guys, I can't multitask and follow the chat. Okay, alrighty. You can move on. You can, next slide. It is not a transfer of land as a legal estate remains with the mortgager. This is very important. I don't know if it's important at the Cape level, but it's important in law overall that it is not a transfer of the league as a legal estate remains the mortgager. Anybody know what is a transfer of land? Very easy, as it says, it's transferring land from one person to another, right? So it's not the transfer of land. It's a literal legal interest. The legal estate still remains with the mortgager. Only thing a mortgage does, like the slide says, is create some sense of security interest. The mortgagee only has a security interest in the property, right? The mortgager still remains with the legal interest or the legal estate, right? Clear on that?
Yes, miss.
Yes, miss.
Yes, yes.
Let me tell you something. I'm gonna need y'all to answer, else we're going to end this meeting because I'm going presuming that I'm talking to myself and Trent alone and Akil alone, and I'm going to just remove everybody else from the meeting and talk to the people who are talking to me. Right? Let's communicate. We're here to help you guys. I can't know where you guys are at if I don't hear the issues. I need to hear your understanding. I need to hear that you guys are with me as we move along. I don't want to leave anybody behind. It's literally 34 of y'all. We need to all be on the same page at the end of the session. You can move on, Trent. So there are two types of mortgages which can be created: a legal mortgage and an equitable mortgage. Go take that off for me, Trent, and someone explain to me what is a legal mortgage. What is a legal mortgage? You guys should have known this. You guys have been studying, right? Well, we should have been studying. Go, Akil.
Okay, if I may. So a legal mortgage basically takes place when all of the legal formalities for a mortgage to be registered have been observed, and the title would also reflect the fact of registration, the fact that the mortgage was registered. While an equitable mortgage, however, is one where the lender is secured by taking the deposit of the title deeds given by the person who owns the estate or owns the property for money borrowed with an accompanying agreement to execute a regular mortgage, or also by the mere deposit of the title without any further arrangement. So it would be less, I guess, secure than a legal mortgage because all of the formalities would not have been observed.
Okay. Very much, in essence, that's what it is. I want you guys to find a way to ensure that, because when you go into exams, especially law-related exams, it's really hard to remember precise definitions. I don't know how you guys study, but it's for a topic like this that is kind of heavy in content. You have to ensure that you find a way to remember how to differentiate these things, right? Because if the topic is coming on mortgage, it will require you to be precise in your definition. So like you said, if the mortgager has a legal interest and he gives the mortgager or mortgagee a legal interest by way of security, then the mortgage is legal. So the legal interest is what kind of interest again, Akil?
The legal interest, wait, hold on, what was the question?
So I'm saying, I read this and I said, if the mortgager has a legal interest and he gives the mortgagee a legal interest by way of security, then the mortgage is a legal mortgage. Explain to us again, what is a legal mortgage? What exactly is being given to the mortgagee as a legal interest?
All right, so basically, all right. There's I believe the equity of redemption, or that isn't one.
No.
Oh, that doesn't different. All right. But
That's what I'm
basically,
asking. I probably am asking it too technical. Probably Trent can provide some bit of clarity.
one
Probably
type.
I'm not clear. Was I not clear?
So the title of
the
registration
definition that
then.
you gave before, you had it on point as it relates to the differentiation between the legal and the equitable mortgage. But I want you guys to make clearer for everyone else is what exactly is the mortgagor giving to the mortgagee in order for it to be considered a legal interest. Trent, go down to legal mortgages for me. We're reading that. A legal mortgage can be created by deed in one of two ways: a demise for a term of years absolute or a legal charge. A demise for term of years absolute is this mortgage is made in a form of a lease of the mortgager's property with a proviso, or the pronunciation may vary, known as the, what I pronounce it again, Trent? Proviso forcessor on redemption. That is basically saying in fancy terms that the lease should be determined when the mortgage is redeemed. Redeemed meaning that when you pay off your mortgage, that's when it will be considered terms of years absolute, right? And then all the capital and all the interest are paid off in full. So if it is at a bank, CIBC gives you a mortgage for 10 years, right? CIBC is holding on to your title for that 10 years, right? When you pay off your mortgage, because that's when you give them the legal interest in your property, right? When you pay off your mortgage, all the capital and the interest are paid off in full. You get back your title, right? And you have now redeemed, considered the mortgage to be redeemed, right? Clear?
Yes, that's good.
Yes, miss, I have a question, miss.
Go ahead. Who is asking the question? Tony?
Miss
Go ahead,
Tony,
Tony.
yes. Miss, is this the case where, like, for example, they give you 10 years to pay it off, miss? Let's say you have enough money to pay it off, you still have to wait the 10 years to fully pay it off?
No, it just gives you 10 years because that's the time in which that they think that the ordinary persons would be able to pay it off. But remember, you know, that with a mortgage, if you get a $20 million mortgage, you're not going to just be paying 20 million, right? And so majority of the times you're paying interest more than the actual mortgage itself. I don't know if you guys knew that. But when you have a mortgage, so for instance, you have a 35, you buy a condo for 35 million up in Cherry Gardens, right? And
Yes.
you are paying every single month on time. You're paying the exact amount. That's why persons always say don't ever pay the exact amount on your mortgage, because if it is that they require for you to pay $10,000 a month, the $10,000 a month is barely just scraping off the interest that was acquired from that was actually put on the actual mortgage itself, the $35 million mortgage. So it requires for you to pay more than you're required to pay. But you can pay off your mortgage if you have the money to pay off your mortgage. The bank just wants to know that you pay them back the money, because that's the only way you're going to actually get back your title. You understand?
Miss, isn't persons normally eligible to pay off the whole mortgage after 6 months?
That's what I'm saying, is that you're able to pay off the mortgage, right? A bank only gives you a time period in which they think is fair for you to be able to pay the mortgage in full. Understand? So like you rightly said, under Jamaican law, after 6 months have passed, you are able to pay your mortgage in full. But how many Jamaicans or how many ordinary citizens are able to pay off a $35 million mortgage after just 6 months of having the mortgage out? And so a lot of banks won't want you to do that because they want your mortgage to acquire interest, because that's how they make the money back. You know? So yeah, that's kind of straying from the point of the discussion. But yeah, Trent, I'm not seeing the PowerPoint. I don't know if it's me alone.
Yeah, 1 second.
No problem. Give us a second, guys. We're trying to acquire a shorter and more precise PowerPoint. Just give us a second.
Yes.
And also, if you guys by chance have a mortgage actual past paper question that you guys would actually want us to go through, that would also work.
Miss, I think mortgage came last year. I could bring up the past paper if you like. Or
Great possibility it won't come this year. So, but you never know with Cape.
yes,
Okay.
I never know.
Here we go. Trent, you want to take the lead or you want me to?
Well, I think you're going good, but as you were explaining in terms of legal mortgages, just to reiterate, a legal mortgage is just basically um a conveyance, really. Okay, so a legal mortgage is a conveyance of a legal interest in the property. So legal interest means that you went to the registrar of lands and your name is on the deed, and you're taking this deed to the bank for them to place a charge. So this would be a legal mortgage. So they would place a charge on your property. So that's just a little layman's terms of a legal mortgage. I hope everyone understood from when Samoya explained. And now we can move on to equitable mortgage. Does anyone know what an equitable mortgage is? Just before we go through this. I think the guy explained it before, Akil, but someone else could give me another explanation, a shorter one based on your understanding of an equitable mortgage.
I'll go ahead. My perspective on what equitable mortgage is where the formalities are not really dealt with properly, and so equity steps in to mitigate the factors of that circumstance. So where you need to get back your land after completing all payments, then equity will step in and allow for you to get that.
Okay, yes, you're right on track. You're right on track. So, could you just repeat it once more for everyone else?
Okay, so equity habitually steps in to mitigate factors that are too strict in common law or inflexible. And so where the formalities are not necessarily followed under the common law principle, that's where equity steps in to ensure that the mortgagee is able to get back his property or his title after paying off his fee absolutely.
Right. Great. So does everyone also understand the definition of an equitable interest? Like, what is an equitable interest in property? You could give me an example.
Sorry, I'm kind of lost.
Okay. So to bring it back on track, we're talking about equitable mortgages. But to have an equitable mortgage, you have to have an equitable interest in property. The equitable mortgage really comes up where there's some type of agreement, but you don't have that legal title. You don't have that name on the registrar, on the deed itself to say that this is my land, but you know that based on certain agreements or conversations between you and the legal owner, that you will have some type of interest in the property. So I'll just give an example. This is very common with husband and wife, domestic situations. So oftentimes, well, before, back in the day, the husband was the only person who could really put his name on the title deed. So then the wife, in the end, wouldn't really have that claim to the land in the event that they divorce or something to that effect. But of course, if the husband dies, then, it will accrue to the wife and their kids. But besides all of that, basically it's where The equitable interest arises where the wife would have done something. Let's say she purchases groceries, she cleans the house, she looks after the house, she does everything on the land. Let's say it's a farmland. She does the plowing, she does everything, and the title owner does nothing. She could bring a claim to say that I have an equitable interest in the property because I treat the property as if I am the owner. So now, in the end, when the money is paid off on the loan, she could have a claim to any property to say that I am the equitable owner of the land because I had an equitable interest. So I hope everyone understands equitable interest in the fact that it's not a legal title, but it's some type of interest arising out of an agreement, or it could be state of affairs, as I said before. You do something in the house, you do the most work, and you feel like you should have some type of ownership, especially in a husband and wife relationship. So everyone got that?
Yes, sir. I understand better now.
Okay.
And just please note the first example with the husband and wife is a very, very popular example that is used to actually explain equitable mortgages or anything really equitable in law. There's always equity always comes into play, especially between married couples who are actually separating or getting a divorce. So yeah. And it's very important for you guys to read the Walter and Longsdale case. Longsdale case is a very, very, very good case to actually solidify your understanding of mortgages or legal mortgage and equitable mortgage. You can move on. I think we can move on.
Okay, these are normally the parts of the syllabus that trick persons up. So you guys could let me know if this is familiar to you. I know students love to say that they never learned it, but let's be honest. So can someone explain the rights of the mortgagor? The first right would be the right to redeem. So can someone explain that right? Don't just repeat what's on the slide. Give it in your own words.
For the people in the chat, we can multitask well here, so we are not going to be looking at that chat to get your answers. So if you guys don't open your mics, then I don't know.
I think essentially this is saying he has the right to, after he repays the mortgage, he has the right to own the property, I guess.
Great. So that's a that's a very good simple definition. So once a person repays the loan plus the interest on the whatever mortgage that they gave to the financial institution, then they have the right to redeem their property. So if you pay off your money, the bank cannot say that, oh, I want this land because it's a nice piece of land. I want this house because the house is $1 million house. Once you repay your loan, you have the right to redeem your property.
I see
Very
a hand
simple.
being raised by Renee. Sorry, Trent.
Go ahead, Renee.
If I'm not mistaken, isn't it that when you're taking out a mortgage, don't you normally have a duplicate where you give the original to the bank or financial institution and you take the copy, and then when you finish paying off the loan, that's when you get back the original copy of the fee simple? Is that the case?
Yeah, that would be the case in terms of the day-to-day operations of those type of agreements. So in reality, well, I mean, the CAPE exam is not really asking you for such detail
Yeah.
because it could be more law school type of information. So of course, there are two copies. The bank will keep the original title deed. You will obviously have a photocopy, and then once you repay your loan, then you will have the right to redeem all of the original documents that you rightfully own. But yes, that's right. But for a CAPE exam, they're not really looking for such detail. I think it's more surface level definitions, but if you
Yeah.
want, show that the run-ins, the day-to-day run-ins of a mortgage, then you could,
Financial institution.
of course, we
Because
could.
in true essence, I don't remember who exactly asked that question or made that point. Things are just going so fast. But anyways, you can't do anything with a copy of your mortgage. A copy of a mortgage can't do anything. Hence why the bank takes the original copy of your mortgage, right? So it doesn't really matter if you have a copy of your original mortgage because it really can't do anything. That's why the bank has the original copy of a mortgage. But like Trent says or said, you don't need to focus on all that. The CAPE exam does not require such details, and that's why it's important to remain within the space of the material that is actually provided for you for your CAPE exam, because you can find yourself being caught up with the details and the intricacies of the topic that you get lost and not remembering the true essence of what you're really studying for the exam. So just keep it surface level. When you reach faculty, you're bad up faculty and then you're bad up law school. But as of now, just keep the basics so you can understand it from the paper too. This will be the easiest part of the law that you'll ever learn. So yeah.
Right. So we got the right to redeem. Of course, legal and equitable would be rudimentary. The legal would mean that you have actual evidence of your ownership. Equitable would be inferences of ownership, inferences of some type of agreement or something like that. So it would be the same in terms of the right to redeem. And I think we could move on from that. So can anyone explain the right to the rents and profits for the mortgagor, that is?
Can you hear me?
Yes.
I think this is where all present and future income, rent, revenue, profits that are or benefits that are derived from the property go straight to the mortgager.
Exactly. So just because the bank has a mortgage or has your property as security doesn't mean that the bank owns your property. They might have the deed, yes, but they don't own your property. So you could still lease your property. So in instances where a person has apartments, if you if you are leasing those apartments on whatever terms, it could be monthly, it could be yearly, all the profits from that agreement goes to you, the mortgagor. Now remember what the mortgagor is: the person who owns the property itself, not the bank or financial institution. So the bank doesn't have any claim to your rents and profits. Even if you fault on your mortgage payments and you miss a month, you miss 2 months, they cannot come to you and say, hey, give me the rent monies from this apartment complex you have here. Give me the profits from this business that you probably have on this mortgage property. Right? So you own the right to all rents and profits that may arise from your property, not the bank. Clear?
Yes, sir.
Yes,
Right.
sir.
Right. Also, I don't really like this, sir. I'm only 22. My name is Trent. So just call me Trent. Y'all putting some age on me there. We're the same age, basically. So
I was just laughing at somebody in the chat when they're like, sir, and they're like, miss. And I'm like, hey, hold up there, please.
yeah, I'm still young. I don't have much age on me yet. So it's just Trent. So can someone explain the right to sue for trespass? Before explaining, I would like you to just give a brief understanding of what is trespass before you explain the right to sue for trespass.
So trespassing is illegally or entering a person's property without their permission. And the right to sue for trespass is where the mortgagor basically can sue for someone entering their property without their permission.
Right, exactly. So in essence, what these rights are saying are that the mortgagor owns all the rights to the property, in essence. So the mortgagor could bring claims in court in relation to the property. So if a person comes onto the land without the permission, or they overstay their permission, so you have permission to be on the property, but the permission expires, the person tell you, get off my property, and you don't come off the property, that becomes trespass, and the mortgagor has the right to sue for that action, right? I see someone just raised their hand. You could go ahead, Jada.
Um, if a person comes from the financial institution that they borrowed the money from, can they sue that person for trespass?
Yes, and this is a bit of a complex question, or the response will have to be
Very
complex because
complex.
you're stepping into the area of company law now.
What
Because
about a debt collector?
sorry,
What about a debt collector?
debt
We're not
collector.
hearing you, you're breaking up.
What if a debt collector comes on the land?
I think that's also
Would
a
that
complex question, because when it comes to debt collectors, they have certain rights themselves to enter persons' properties, so it wouldn't be in itself trespass. But let's just say it's a visitor, or I think most of you guys did occupier's liability. So let's say it might be a visitor, occupier, some other person who comes onto the property. So in relation to a person working at the financial institution coming onto the property, they can be sued in their personal capacity because they are separate and apart from the company itself. So if a person comes in from a person who works at First Caribbean International Bank enters your property and saying, oh, you owe money to the so and so and so, you could sue that person. Unless it's a person, of course, as I said, this is complex, unless it's the manager or some person who controls the image of the company who comes onto your property, then you could sue the company itself. But that, of course, you don't need to know all of that for right now. All you really need to know is that the mortgagor has the right to sue. They have all rights over their property to do anything in relation to that property. So they could sue if someone comes onto their property or does anything wrong to their property. So whether it be nuisance, it could be anything, right? It's just basically to say that the financial institution has no rights over the property. The only rights, and we'll get to those, that the financial institution has is to redeem their monies owed to the financial institution, right? But all of these basic rights in terms of rents and profits, trespass, wrongdoings, all of these things are the mortgagor's rights. All you need to know is that it's your land. It's not the bank's land. It still remains your land, even though the bank is holding it as security. The only agreement you really have with the bank is that if you don't pay a debt, then they could take your property. So it's mainly in relation to debt rather than these different type of claims that the mortgagor could bring in their personal capacity. I hope everyone understands that.
And just to make clear that the mortgagor could only take what you guys agreed for them to be collateral, right? So if it's a house, they can only come back and claim the house. Them can claim your car, your dog, a house you had in Montego Bay. They can only claim the house that was mortgaged.
Unless, of course, when they come to claim the property value is lower than what they agreed to, then they could take something else to make up for the value. So if you have a car or something like that, then they can redeem other things
In
to
that
make up.
case.
In that case, if it's not.
It just has to be of the same value, I believe,
Yeah.
of what it is that you borrow. My apologies, okay, the mosquitoes boy.
Yeah, Jada, you have your hand up?
What about the contents of the house? Could they take that as well?
So this is moving into real property now. Of course, I think you guys would have learned fixtures and chattels. So in certain jurisdictions, of course, maybe St. Lucia, they could take certain chattels, but in almost all jurisdictions, in Jamaica for sure, they could only take fixtures. So you cannot walk with your ceiling fan because it's affixed to this the building in a with a certain degree of annexation. I think you guys should know that term. So once there's a certain degree of annexation to the property, which would be fixtures, then they can of course take that along with the property. But if it is like it's just a standing lamp or your couch, they cannot take your couch, they cannot take your stove, they cannot take your fridge, all of those things. They could only take you could only take the property itself and what is affixed to the property in a very serious way. So maybe a mirror might be affixed to the wall, but you could take a mirror unless you're removing it would break the mirror. But they could take the property and anything seriously affixed to it. I hope that answers the question. Right, so you can move on to a right to grant valid leases. And this is the same thing that I was saying before. They could have rental properties, they could enter agreements with other persons for them to live on the property, for them to use the property for business, for them to use the property in any way, as long as it does not affect the agreement that you have with the institution. Right?
Yeah.
But remember, consent is also important. So you can't just do any and anything on the property, especially if it may diminish the value of the property, because that will end up disadvantaging you as the mortgagor. So you have to go to the mortgagee for consent to use the property in a certain way. Right?
Yeah. I was gonna bring up that from the first statement, the first, right? I mean, the second, I mean, but I saw that it was in the
Yeah.
slide.
Right.
Shane,
I
give me
hope
a second. Let me just acknowledge that Keandre is with us. Just a little brief introduction, because I'm really proud of my friends. Like all my friends are like smart. Keandre in my year was the valedictorian of our class, and yes, so he's here. So you guys have persons who have been there and done that and who have excelled at it. So please feel free to ask your questions to them.
not to put Keandre on the spot, but Keandre does teach, and tutor. So I feel like Keandre could possibly take over if he's in a position to.
I guess we have a few more topics to go through, so I guess we could all share. So you seem to be doing excellent at this. You're about finished with this slide.
Right. So this is just some more details on the right to redeem. So if the mortgagor failed to redeem his property on the exact day fixed by the agreement, then the estate of the mortgagee became absolute and the mortgagor's interest in the land was extinguished. So what this is really saying in layman's terms is that if the owner of the property, the owner with interest in the property, fails to pay on the agreed date, then the mortgagee will of course own the property. That's it. It's no longer your house, it's no longer your car, it's no longer whatever property you mortgaged, right?
Yes, Mr. Luke.
However, Equity stepped in at this point to say that basically the mortgage is really to give to the financial institution as a security for money that was lent. So the mortgagor can redeem his property at any time after the contractual date has passed. And of course, that is the law today. So the bank in today's world cannot really just take your property and then you have no claim against that. you still have the right to make good on your payments in some way. Of course, that will be subject to further agreement because, you know, you can't take another 15 years to pay off a debt that was supposed to end, of course, 15 years ago. But you will still have the right to redeem your property, to make good on your payment. And that is called the equitable right to redeem. And you guys could take this case. I'm sure you you probably learned this already. Yeah, Renee.
In the case where the mortgagor failed to redeem the property, can you sue for damages?
The mortgagor suing for damages.
No, can the mortgagee sue for damages from the mortgagor if he failed to redeem the property?
Yes, yes, yes. So if the mortgagor fails to make good on his payments by a specific date, then yes, the mortgagee has the right to claim for that property. And if the value of the property is not enough to pay the remainder of the debt that is owed to the financial institution, i.e. the mortgagee, then the mortgagee has the right to further assets to fulfill that debt. But in my opinion, I think this mostly happens, especially when a person dies and they still have debts remaining. So certain assets that they have will most likely go to fulfilling certain debts that they owe to any financial institution.
But to add to that also, just two things I wanted to add. First, that's where foreclosure comes into play. There's a bank knows exactly how they're going to get back their money, right? And so if it means they're going to throw you out of the house that you're currently living in, that is theirs, considered theirs, because you have yet to pay them off, then they will sell that property and get their value. But as it relates, most persons, actually, most persons when taking out a mortgage, gets a mortgage that dies with them, right? So if it is a case where the person dies and the mortgage is still outstanding, it dies with them. Everybody understands that? So if you're 35, a 10-year mortgage, and you happen to die in the 50th year of your mortgage being owed, you have some mortgages or some agreements that allow your mortgage to die with you. So you just die and nobody is obligated to pay that mortgage anymore because it actually dies with you. So that property just goes into your estate. But yeah. Trent, are you talking?
No, no, no.
Okay.
I'm just giving some time to read through the slides. So you guys could look at this. This is the equity of redemption that we mentioned before. Well, actually, this is different. So the equity of redemption, you could just read through it. All the information really is here for you. So it's really the sum total of the mortgager's interest in the mortgage property after the mortgage has been created. The equity of redemption comes into existence as soon as the mortgage is created and increases in value with each payment made by the mortgagor. Whereas the equitable right to redeem arises after the contractual redemption date has passed, and it is a right to redeem the property. It is an equitable interest that represents the value of the mortgager's interest in the property after it has been conveyed to the mortgagee as a security and is freely transferable. So, as was stated by Lord Hardwick in Casbourne and Scarf, an equity of redemption has always been considered an estate in land, for it may be devised, granted, or entailed with remainders. The person, therefore, entitled to the equity of redemption is considered the owner of the land. Yes, Akil.
Yeah, I have a question. So, as it relates to an equity of redemption being able to be devised, how would one go about doing that?
Could you repeat your question?
Basically, I was asking how would you devise an equity of redemption?
Devise an equity of redemption. I'm not sure if Keandre could step in at this point if he's still in here, but
Because based on what Lord Hardwick said in Casborn and Scarf, an equity of redemption is considered to be an estate in land for it may be devised. So I'm wondering if it would be the similar way in which like a regular estate in land would be devised, if that's the same thing for an equity of redemption.
oh yes, okay. Well, as it said, the equity of redemption is an estate in land. So the estate is really the interest in the land, right? So you could devise it, you could grant it, and you could it could be used as a remainder. I hope you all understand that that's real but yeah. So as I was saying previously, once you are the mortgagor of the property, you hold the interest in the asset, right? It's only being used as a security in the event that you fault on your payment. In the event that you fault on your payment. So it's not the financial institution's asset, it's not the financial institution's property, it's not their car, it's not their house, it's still yours. So you could do whatever you wish to do, of course, with the mortgagee's consent, but you could do whatever you wish with the property. So you still hold an estate in the land. The financial institution holds no estate in the land. Your land is simply, or the property is simply collateral.
And that's why when we're saying at the very first, before we went in depth with mortgage, is that what we need you guys to understand is that you hold the actual legal interest in the land. You're not handing over your interest per se. You're just allowing the mortgagee to have something, like Trent rightly says, collateral, just in case, because you're borrowing from them. They need to have something of the same value for which they're lending you, right? So it's an exchange, just as though it can be related to contract law. What you're offering the person needs to be something of the same value, right? So you're getting a mortgage and you're giving them the house that is of the same value for them to say, okay, in case you're not able to pay back the mortgage, I have something that I can use to as a replacement or a claim against what you failed to actually pay, right? So once you guys understand the foundation that you're not giving these people, it is yours, the house is yours, right? The car is yours, the land is yours. You're just giving it to them as a collateral, right? They literally only have like an equitable interest in the land because of the fact that you borrowed from them. And I just fear that you guys are the questions are good questions. It shows that you guys are reading, but I also think that you guys are going too far in depth into things that are really not of essence when it comes to your CAPE exam. And I find that you're going to be wasting time trying to concretize top concepts that only requires you to have a basic and foundational understanding of it. Alrighty, we need questions. I don't want this session to feel like we're having a lecture. Sessions, nobody here is a lecturer. We need to know the questions that you guys have. So we need to, moving forward, we need you guys to ask the questions so that we can answer the questions that we can move on. We're not going to spend the entire night. We don't have the time to spend the entire night going through long topics with you guys. I need you guys to ask those questions and we're here to answer questions, right? We discuss mortgage because I do understand that mortgage is a topic that probably needs to be a little more discussed a little more in depth than a lot of other topics, and we understand the struggles as it relates to that. What we need, this is a revision session. The role and responsibilities of your teachers in your classroom time and your contact time is to teach you these topics. We're here to sort of bridge the gap between what you guys don't know. We'll not be sending the slides to anyone. The slides is our intellectual property, of which we take very seriously, and we would hate for you guys to share our material without our permission. So you guys need to take down as much of the information as you can, but as it relates to forwarding our material that we have used our brain power and our intellectual property to produce, will not necessarily be happening, okay? Do we have any other questions as it relates to mortgages? Can we move on to another topic? Not to lecture like we just lectured mortgage, but for you guys to ask questions. Because we really don't have.
No, miss, I don't think so.
Okay, a question. I do have a question.
Go ahead.
In a decided case, I'm so sorry if I said in a decided case because I'm not really familiar with the name as yet. However, also I don't want to go too complex because that's just how my teacher teach and that's how we have to understand. Anyways, there's a case where a person who owns a store filed for a mortgage from another financial institution. And to clear the loan, the institution basically sent some goods to that business to sell. So basically, in the midst of paying, some of the money would still be removing to clear the debt because you're selling for that person. However, after the person who took the mortgage finished paying for the loan, the institution is still sending products to that person, even though the loan is cleared. So should it be that there's any attachment still going on or any ties with the mortgager and the mortgagee after paying off the loan?
I feel like you lost me in the length of the question. Just ask me the actual question. What exactly is the question you're asking?
Should there be any ties remaining between the mortgager and the mortgagee after finish paying off the loan?
No, there are no ties after you have paid off the loan. The only arrangement that you have between a mortgager and a mortgagee is actually the mortgage. And so once the mortgage is paid off in full, you get the legal interest of the land, which is your title in a hand, which makes the property yours legally, right? You're allowed to sell it, you're allowed to lease it, you're allowed to rent it, all of the above and more. It's yours. They can no longer have an interest in the property, not even an equitable interest in the property, because you have fulfilled your obligations under the contracts that you have signed and committed to. Question answered?
Yes, thank you.
No problem. So let me just read Kayla's question. What if the mortgagor breaches a term in your agreement? Does that nullify the mortgage? No, it doesn't. And
It- Well, it kind of depends because the questions you guys are asking are basically contract law questions.
yeah,
A mortgage is a contract. So when you think of a mortgage, it's no different than, not because it's taught under a different topic, means that it's separate and apart from the other areas of law.
still a
Most of the
contract.
So contract law is still the basis of it. So as the young lady was asking before, if there would be any contractual relationship continuing after the mortgage is paid, no, because the performance was already done. The contract was performed, there's no contract remaining. In relation to this, it depends on the type of term that was breached. So of course, you guys would have known that there's three types of terms. There are conditions, warranties, and innominate terms, right? So if it's a condition that was breached, then yes, the contract is voidable or void if it goes to the heart of the contract. So if it's a term to say that you cannot sell your property to anyone else, that's a condition inside of your mortgage contract, then you end up selling the property to somebody else, then yes, the contract can be void. But also, there might be more intricacies because the mortgagee could be able to reclaim on something, but the contract, of course, in essence, would end if it's a condition.
Give me a
If it's
second, Trent. Give me
Yeah.
a quick second. What I want you guys to understand is really the complexity or the seriousness that a bank takes in requiring your performance in the contract. A bank is not going to be like a regular landlord and tenant contract where, oh, you breach a condition and it kind of totally destroys the very essence of the contract, and the landlord going to put you out and put your things them out and all these things. A bank is going to redeem that which is theirs, right? And if it is that you, like Trent said, violated the very essence of, or the very body of the contract, it becomes void or voidable. But in most cases, and I'm sure if you guys have been reading the cases, most cases as it relates to bank, and which I consider the lenders in this situation, they're going to claim that which is theirs. And so you're not going to get a question where there was that sort of breach. I've never seen it, and I've seen a few mortgage questions over the years, and I've never really seen it structured in such a way that it will talk about nullifying the very essence of your agreement. But I could be wrong. It may be a new thing. Like I said, I've done this a little time back, but yeah, in the true essence of contract law, like I said, like Trent rightly said, contract law is the very basis of many areas in law, and it really comes down to what exactly, like Trent said, was actually violated. Go ahead, Trent. My apologies.
Yeah, that's cool. But basically what Samoya said, everything is correct what she said. I see persons have their hands up. You could go ahead, whichever one was first.
Okay, I was first. Good night. So, for instance, what if the mortgagee loses his or her job and the mortgager came and redeemed what was mortgaged? For instance, they came and sold the land.
Pause. Restart your question, but use the terms correctly. The mortgagor is the person who owns the land, the property, and mortgagee is the institution. So ask it again.
Okay, sorry. So the mortgager came and redeemed what was set for collateral before the time because the person lost their job. Isn't that a breach?
Okay, so you mean the mortgagee comes to redeem once the mortgagor loses their job. Well, the mortgagee is not responsible. There's a lot of rain falling right now, so if you're hearing that in my audio, then I apologize. But let me know if you could still hear me.
Yeah, we're hearing it clearly.
Yes, I can still hear you.
Okay. The mortgagee is not responsible for the mortgagor's financial situation. Of course, when you apply for a mortgage, you have to state whether you have a job, how much you're making at the job, all of these different things. So the mortgagee knows that you are going to pay the mortgage, you have money to pay them back, and it is enough money to satisfy the mortgage debt in a reasonable time frame, right? So if the mortgagor loses their job, then the mortgagee has nothing to do with that. The mortgagor needs to get its ducks in a row and find a proper job to pay its debts, because the mortgagee has the right, based on these rights, to redeem the property in the event that the mortgagor, as we said, does not pay their debt.
No, the thing is they came and collected it before the time was up. So that's why I'm asking if the mortgagee is in the wrong or not.
Maybe I'm not clear. Ask the question one more time. Sorry for that.
For instance, the bank came and collected my land. They came and sold it because I lost my job, but the time wasn't up on the mortgage as yet.
No, but the thing about it is, what I want you guys to understand is that if it is a bank gives you 10 years to pay your mortgage, you have a responsibility to pay your mortgage per month. And so it is stipulated within your contractual agreement that every month you are required to pay X amount of money. There are terms within the contract that states that if it is that you have failed to pay at least 3 months of your mortgage, or you fail to do whatever the circumstances may be, they have a right to actually put your property in foreclosure. But I allow Keandre to add, because I see his hand. Probably he can provide a better explanation. Go ahead, Keandre.
Hi, goodness. I'm just making sure that you guys are hearing me.
Yeah, I'm hearing. Go ahead.
Yes. I think the point that is really trying to be driven across is that the bank in these cases, they do not care about your personal circumstances.
Exactly.
You have signed an agreement that this is what I am going to do. So if the terms say that I'm going to pay you $100 every month, if you don't have $100 every month, the bank is free to come and take what is worth $100. Now, realistically, let's put it this way. Let's put it in terms of a property. Let's say you have a house, the house is worth $10,000. And do you have a contract with the bank that you're going to pay, let's say, $10,000 worth of monies to them? And you keep paying, you keep paying. You get it down to $5,000. And let's say you have, let's say, 5 more months to pay. But at this time, you can't afford to pay that remaining $5,000 because you're out of a job. The bank doesn't even care that your property was worth $10,000. They're going to come and they're going to sell your property for the $5,000 that you are owed. So the bank doesn't really care about your personal circumstances. The bank just wants whatever you have said that you're going to give to them. It's very unfortunate, but it's just the reality of how it operates. That was my addition.
Yes, and I want to just reiterate Keandre's point and Trent's point. Remove the emotions from it. A bank is a financial institution. This is how they make their money. Nobody could give, excuse my language, a rat's whether you are able to pay the $50 a month like you said that you were going to pay. Only thing the bank cares about is the fact that you said at the time you guys made the agreement that you were going to pay $50. If you lost your job and you're unable to pay the $50, the bank has the right to come and take back their property because you no longer can fulfill your obligations under which you signed the contract to actually carry out, right? And so if it is that you have lost your job, it is your responsibility to find another job that is able to cover the $50 that you agreed to cover. The bank does not care if it is that you lost your job, somebody for you died, your child sick, your dog died. They do not care. What they do care about is the fact that you agreed that you were able to pay $50 a month. If it is that a month, 6 months pass by and you're not able to pay it, they're going to come and sell your land if it was valued. If you bought 35 million from them and the house is valued at 35 million, and it now, like Keandre said, value is 60 million, they're coming to sell that property for 35 million because that's what you promised that you were going to pay them back in full. They do not care, okay? So yeah, your responsibility, your problems. It sounds like an issue. You alone have to deal with those circumstances. The bank is not a therapy session. The bank is not a psychologist. You have to find a way to pay them back their $50 a month like you agreed to pay back. We understand?
Okay, yes, thank you. Because I saw this on a mock exam paper. So thank you for the clarification.
Perfect. Like Sarah said, give them back their money. They don't care about anything else. Solve your issues with the priest. Repent of your sins. Nobody cares. Pay them back their money. That's all they care about. And we need you guys to see them as just that. You lend them the money. You went there happy. You guys shaked on it. And you borrowed the people money. They want back their money in full. Right? They come in to take back the properties. That's why you see foreclosure sign on so many people's homes. And you see like how when they buy furniture from courts and you don't pay them, you see one big white truck coming back to take your furniture. That's the bank for you. Pay them back the money. Moving on. Next question. Kayla, is that a new hand or an old hand? Keandre, is that a new hand or an old hand? Alrighty. Any more questions? Let me check the chat. Wow, the chat is going off. So where exactly does the right to redeem and redemption come into play? What exactly do you mean? Gabriella?
Miss, I think the person is asking, Miss, what's the point of the redeem and the redemption part?
Like we were reading, if you guys, you know what, I want one of you guys to read what the legal right to redeem means.
So I'll read it, Miss. I have no problem. At common law, if the mortgagor failed to redeem his property on the exact day fixed by the agreement, then the estate of the mortgagee became absolute, and the mortgagor's interest in the land was extinguished. Equity considered the common law rule that failure to repay the loan on the day fixed by the mortgage resulted in the loss of the mortgagor's estate to be unduly harsh, bearing in mind that the purpose of a mortgage was merely to afford security for a loan. Accordingly, equity permitted a mortgagor to redeem his property at any time after the contractual redemption date had passed, and this remains the position today. The right is called equitable right to redeem. In Thornborough v. Baker, 64.
You basically got the essence. So the right to redeem is the mortgagee's right. The mortgagee's right to redeem the property comes into play when the mortgagor fails to satisfy their debt.
Exactly.
Okay. So basically, the mortgagee, the bank, they can take back the property if the mortgagor, which is the person, doesn't pay back in time.
Yeah, that's exactly. Listen, let's put it in layman's term, right? I tell you, right? We have an agreement. You see me post on Instagram that I'm selling an iPhone 15 Pro Max, right? We get that? iPhone 15 Pro Max. You come in my DMs. You said you want to buy my iPhone 15 Pro Max, right? You said you can't pay me in full for the iPhone 15 Pro Max. However, you're committing, because I said the iPhone 15 Pro Max is $200,000, right? And so you're required to pay me roughly $16,000 a month, right? And you have 1 year to pay it off. 1 year. That's the commitment, right? I give you the iPhone 15 Pro Max and I say to you that I want something of value, right? That would match up to my iPhone 15 Pro Max. So for instance, my iPhone 15 Pro Max have some title. I take the title from you as the owner, the person selling the iPhone 15 Pro Max, and I give you the iPhone 15 Pro Max, right? 6 months pass, you don't pay me for my iPhone 15 Pro Max. In the agreement, I said to you, if it is after 6 months and you have failed to pay me for my iPhone 15 Pro Max as committed per month to pay the $16,000, I have a right to come back and take my iPhone 15 Pro Max. 6 months pass, you have yet to pay me for my iPhone 16 Pro Max for the $16,000 a month as committed. I'm coming back to take the iPhone 15 Pro Max because why? You have failed to honor your agreement to pay me the $16,000 per month for a year in order to pay off the $200,000 that the iPhone 15 Pro Max is worth, right? So the iPhone 15 Pro Max is the house, and the title that is given to the bank is your original copy of title that is considered legal or equitable interest, right? They're taking that from you. They have a right, if you don't pay the people back their money, they're going to come and take that which is theirs. You can't expect to live in the people's house and not pay the mortgage. You can't expect to live for free. It wasn't a gift. You signed an agreement. It was a contract. You have to honor your contract. And if you have failed to honor your contract, you have breached your contract. And so when you have breached a contract, you provide the person in which you have breached within the contract to claim against the breach, right? So I don't know what kind of fairy tale world we're living in, but that's how it works. They have a right to come back and redeem from the agreement or the breach that you have failed to pay for your mortgage, because it's the right and equitable thing to do. Equity doesn't allow only one person to benefit. At the end of the day, a bank is a lending and financial institution, and they can't just go around and just give free houses to everybody. That's what Food for the Poor is for, not a bank. Right? We understanding? Gabriela, see your hand up. Go ahead with your question.
Okay, so I had good night, by the way. But
Good
I had originally asked the question in the chat, and the only part I understand the part about, at the end of the within the contract, it would stipulate when you're able to, get back your things if their end of the contract is not being fulfilled. But what I'm not connecting really is the part about the redeeming and the redemption, because previously I was understanding that if you could not pay, then the right to redeem was basically giving a sort of leeway for the person to either pay, like even though the contract was breached, or pay after which the foreclosure or whatnot was going on, that they could still repurchase. Could you just give some clarity as to how that part of it relates to that part, basically?
I'm very sorry. I was so distracted reading and responding to a message in the chat. So my apologies. Repeat your question one more time for me.
I think there's some assistance.
Okay, go ahead. Because I was just answering a question in the chat and I totally zoned into the question. Go ahead, Trent.
Okay, so the equity of redemption is basically what the contract is about. It's basically giving the mortgagor the right to repay their debt. And in giving them the right to repay their debt, they have the right to redeem their property. And if it is that they may fault on their payment, then they also have the right, even if the date has passed, for them to repay their debt, to still repay their debt. Now, that is not to say they have an extra 2 years or extra 3 years to still pay the people back their money. But the bank cannot necessarily just say, okay, you missed for 2 months, you missed for 1 month, give me a land, give me a house, I'm going to sell it. You still have the opportunity, which is the equity of redemption, to redeem your property by paying for what is rightfully yours. And as we explained before, the right to redeem is the mortgagee's right, to take your property if you fault on your payment, but it's not instant. So don't think of it as if, you know, it's a one-time thing, a snap of a finger, you don't pay a debt, the bank is taking your property one time. There's more that goes into it. Of course, it's people's livelihoods, right? So if it is that you don't pay your debt on time, or you fail to pay it by the end of the contractual date, then you still have the opportunity to make good on your debt payments. And that's your equity of redemption. That's the
Sir,
mortgage of redemption.
I mean, Trent, sorry.
Yeah.
So the equity of redemption is the last chance to catch up on all past payments and to get back in right standing with the mortgagee.
Yes. Yes, and it's
Okay.
also your right, generally. It's your right to pay back what is right. Pay for, it's your right to pay back debt to get back what is right for yours. So it's general, it's general. It's not just about if the date passed, although that is also a part of it. But it's just you, it's the process. You paying the bank for some money that was lent to you. The security is already there. The house is already there as security, but it's you paying the bank to clear off that security. So that is the equity of redemption. Because you still have that interest in the property. So it doesn't just, the interest doesn't just disappear just because you fail to pay. You still have an opportunity to pay. So you're right. I hope everyone understands that.
Yeah, if I may add, Trent, I think to summarize basically what you're trying to get is that so long as the property remains intact, the mortgagee, still has his security. So even though you have delayed in your payment back to the bank, once the property remains intact, then the mortgagee essentially still has his security. So that gives you the opportunity to continue to pay towards it. But like Samoya said in the beginning, that doesn't mean that because you have the opportunity to pay, that you should, let's say, take a year to pay something that you should have paid in a month.
Come on, guys. This is thank you, Kendra and Trent. You guys we need to wrap up mortgages. Are there any other questions? Unless you guys just want to discuss mortgage and it's already 8:21.
Miss, you said you wanted us to do a past paper?
If you guys could provide a past paper, which past paper question, could you just drop it in the chat so that we could all see it? That would be perfect.
That you guys don't understand though. Not one that is simple like the definition of a contract.
Exactly. A problem question, preferably. And for some, I realize that a lot of persons are reading, which is good, commendable, because if you were not reading, you would not be able to have these questions. But I also fear that you guys are overthinking some very simple, straightforward topics, and you're analyzing as if you're writing to judges. A one is a one here, simple, straightforward. Answer the question being asked. Stop overcomplicating it. Straightforward. Let me tell y'all something. Jaylon, I hope that's a pronunciation of your name. Let me tell you something. Two of us on this call, we're teachers, right? And also working people. Some of us just finished exams. We did unit 2 of law few years back. We do not have those sample responses to anything, right? A lot of this information, as we go along, we're refreshing our minds, teaching it to you, right? Kaylee, we currently don't have a teacher, so I'm not sure how to approach it. Drop a question in the chat and we will work through it together. Okay, I just see a paper. I just see Kayla dropped her. Let me see.
Big up, Kayla.
I'm trying to open this thing that Kayla sent. Kayla, I don't know why I'm not seeing your, okay. Trent, did you just want to continue sharing or you want me to share?
The past paper?
Yeah.
Yeah, I can share the past paper.
Alrighty. So it's in the, she shared it in the chat. And this is where you'll hear, well, we will try as best as possible to work through it with you guys. I opened that and I just strict liability. The first thing on the paper.
Let me see. How does share from PDF now? I feel old. It's not showing up.
I can't help you.
Okay, let me type y'all seeing. Okay, it doesn't seem like I could share my screen, honestly. But I feel like we could just read out the question because it's just the question and blank lines. There's nothing really to see.
Are you seeing my screen?
Yes, we're seeing your screen.
And I just have to close up my WhatsApp so you guys don't be all up in my business. Alrighty. Let me see if we can go down to something having to do with what we were just discussing. Was the paper this easy? Trent, Keandre? Was it define and
Yeah.
it was always that?
For me, it wasn't.
It wasn't like this for me at all.
It wasn't either because we did it in the same year, but it was it is.
We just, oh gosh, wow.
There you go. Since COVID.
Okay, why you guys want us to do this paper exactly?
That's the problem question there, Samoya. Let's go back
This
up.
one, but it has nothing to do with what we're just discussing. Okay, we can go ahead and discuss it.
I think what we should do, I can't remember the name of the young lady that asked, but maybe she should point us to the question that she's looking at. Because I don't think I see a mortgages question on this,
Exactly.
this exam.
Exactly. And I feel like this paper would not really do justice to anything really. Because these are concepts that you guys should have down pat. I see a crim question. Well, not a crim question. That looks like a crim question. No, you guys don't do crim in unit 2. These are, you guys. All right, let me not.
Looking at this paper, if I'm being honest, what the paper seems to do, I'm not sure what year was this. This was probably during COVID.
Yeah, this was
what the paper seems to do is really to test your understanding of basic concepts. Once this paper says to you, once you have the basic understanding, then you can answer everything else. If this paper appears difficult to you, then I think we have some work because we are clearly far behind.
Guys, we need another paper because I'm not sitting and discussing with you what is strict liability and what
Well, I
two
mean, I
cases.
guess we can give them guidance because I think you guys should answer the questions, and if it is that you're too far off track, then maybe we could help you be on a straighter path. But not to give you the answers though. I think you guys should probably have the answers to these.
All right, let's go through this paper quickly. We can do this in 10 minutes. What is strict liability? Define it for me. And I don't want a textbook answer. I need an answer that came from your brain.
Not the liability that is strict.
Listen.
I
Y'all
don't need
very
to.
unserious, you know. Boy, if you don't. Listen.
My
Somebody give
suggestion to you guys, right? Since we're clearly not getting the answers to these questions, my suggestion to you guys would actually be to take this past paper, this one that we're viewing right now, and to almost use this as like a it's gonna sound bad at this stage, but like I start to making notes because define the term strict liability in taught. Two cases in which strict liability applies. I mean, that's kind of like what you learn on day one. So if you're not at day one, I mean, you can't really expect us to get you to day 200 and something now that you have the exam. But what is good is that after you use the answer to these questions, then you would be able to literally apply to any question because that is how law is. Once you have an understanding of the basic concept, then you can apply to anything else without seeing a past paper question, once you have the basic concept in your mind, then it's very easy for you to apply to anything else. And I think another to Samoya, another paper was sent in the chat. I think that has possibly has a mortgage question on it.
I can't tell you why here just sharing my screen and forgot that the chats are just open there. Guys, I'm tired. I'm sorry. My apologies. Let me just open. Where's it was sent? I'm not seeing.
If you scroll up a bit, it's a 2023 question.
Okay.
I see y'all still asking what liability is in the chat. I see someone gave a cool definition of strict liability. So they said this is where the defendant is liable to the tort, regardless to if they had the intention or if they were negligent. So right, basically, mens rea is not a thing in strict liability. It's just the actus reus. So once you commit the act, then you're liable for the offense. It doesn't matter if you intended to do it or you thought that it would be cool or you think that's whatever. It don't matter what you think. Once you commit the action, it's strict liability. You're liable for it regardless.
Is you guys write this question? On the teachers write these questions? Because I never see an exam paper structured like this. Are you guys seeing?
No.
Yes, I am. Samaya, I feel like this question is actually a great question for the participants to answer based on what was said here tonight. Because having read the questions, I think Trent has covered, based on what I heard, almost the answer to everything on this sheet. So maybe what we can do is give them the opportunity to speak, and then we correct accordingly.
I was never going to speak. They have the most opportunity right here. Go right ahead. Take it away. We are COVID babies too. There are no excuses. Travoya. Go ahead.
Define each of the following as they relate to the law of real property. what is a mortgage? Sir, isn't that the person borrowing the money? Or sorry, that's the person taking out the mortgage from the bank or from the mortgagee.
Okay, let's start over. On CAPE exams, you have to read very carefully, yeah? Look at the words very keenly because you could define something that they're not asking for.
It asks for mortgage, not mortgagee.
What is a mortgage?
Mortgage.
It's an agreement between the mortgager and the mortgagee to use land or anything as security for a loan.
Okay. But the mortgage is not the agreement itself. The agreement has its own name. The mortgage is the security. The mortgage is your interest in the property that you're giving for something in return.
Hello.
Ask Keandre?
I'm asking if you're hearing. Oh, you're hearing. All right, good, good. I was talking for a long time, but my microphone wasn't working for some reason.
Oh,
So
okay.
a mortgage is basically a real security for the repayment of a loan.
Thank you. That was short and sweet. All right. 2 marks. 2 marks given. Right, so somebody define mortgagee.
Sorry, I should have raised my hand. But basically, the mortgagee would be the financial institution or the bank that would be receiving the repayment. The bank would have give out the security. We don't really know how else to put it, but the mortgagee is the financial institution in the whole process.
Yeah, in essence.
And the mortgagor is whom?
What's that? Sorry.
That question is not on the paper, but I'm asking, and the mortgagor is whom? Who is the mortgage?
Oh, the mortgagor would be the property owner.
Okay, right. So the mortgagor is the person who basically is borrowing. Yeah, so next question. Explain two rights. I think I saw those when I came in, so y'all should know those as well.
Okay, so I really should have raised my hand. I'm so sorry. No manners tonight. Okay, so all right, so one right would be the right to redeem, and there's also the right to rent. Would it be the rights to rents and profits? Sorry. So those are two.
And then the question asks you to explain. So you stated, I'm waiting for you to explain what are those rights? I don't know, so tell me. I really don't know. I'm just saying a bunch of words that I don't understand.
Yeah, you need to give us a one decided case or relevant legislation. We are the examiners. Give us what we asked for. Right now, your answer is putting you at a 3. Claim you're not your grade 1, please. Answer the question in full. It's 6 marks. Go ahead, and I want the same person, Akil, Mr. Never have his manners today, like you said. Come on, work hard for that grade 1. Answer the question in full. You know the information.
Oh,
We are
grade 1.
examining. Go ahead.
Oh, grade 1. Okay. All right. So I'm not really sure about the case for the right to rents and profits, but essentially, despite the fact that the mortgagee would have the deed to the property, the mortgager would have the right to receive any profits that would come from whether or not it's a lease agreement or oh no, primarily like if it's a lease agreement, the mortgager would have the right to receive the profits that come with that. And for what was the other right I had mentioned? Oh, the right to redeem.
Right to redeem.
Oh, all right. So basically, I don't know exactly how to put it into words, but essentially, the right to redeem is like where the mortgagor has the right to redeem the property by discharging or terminating the debt that was secured by the mortgage within like a reasonable amount of time. So if the agreement is 15 years, then if the mortgagor does it in 13 years time, if he discharges the debt in 13 years time, then the mortgage would be redeemed, if that makes sense.
Yes, I feel confused.
Right now I'm confused too. I'm not
And I'm
really
just
sure
using
how
a
to
whole bag
put
of
it.
words and just saying a bag of things. Simplify your answer. Think about what you're saying. Does it
Basically
make
like
sense?
basically the mortgagor has the right to get back the property by paying off the debt within the specified amount of time based on the terms of the agreement.
And that's what the right to redeem means?
I believe so. I hope I can
You
be
believe
corrected.
so? Or
Yes.
so?
Huh? What you say, miss?
You believe so or is it so?
Based on the nature of that question, I'm going to say it is so. And if
Miss, we can
I'm
help out here,
incorrect, then
miss.
hopefully I will be corrected.
Come in, Tony, to see if you can help your colleague.
Yes, miss, me I'm gonna try help you, miss. So the right to redeem, miss. This just means you have the right to repay all the money or monies that are owed and that you can recover the property hereby after.
Yeah. Just to
And
end this question, the right to redeem goes for both the mortgagor and the mortgagee. So the right to redeem you just explained was for the mortgagor, which is correct. And are you just gonna explain the one for the mortgagee?
How does it benefit the mortgagor?
how does the right to redeem benefit the mortgagor?
Yes, it's a right that benefits, like Trent says, both parties to the contract. You just mentioned how it protects one. How does it protect the other one?
Yeah, how does it protect the mortgagee in this instance? Okay, I think you answered for the mortgagor, right?
You answered the mortgagor a while ago. Mortgagee, the lenders, the bank. How does it protect them? What do they have the right to do in failure that you're not able to pay?
Miss, is that the miss no, miss. Honestly.
All right, Sarah, are you offering some assistance?
Basically, although the person has like the mortgage, Jara has the equitable right to redeem, so they can have the opportunity to pay off their loans and stuff like that there for the bank. The bank has the right to take their property or anything of value from them if they kind of abuse the equitable right to redeem. So say you haven't paid your mortgage in like, let's say 2 months, you would have the equitable right to redeem. But if it goes on to like 6 or more months, the bank has the right to take away the property or anything that you have under value with them that you placed a mortgage agreement under.
Yeah, you're correct.
Are you from Barbados?
So the answer was the equity of redemption.
Workside.
Yes,
Miss,
please.
Who just said answer that question a while ago? Who just asked that question?
Miss, my lost, miss, my confused, miss.
Is you confusing yourself? Is you confusing yourself? Alright. Probably I not explaining it right. Probably Trent not explaining it right. Probably Keandre will explain it, and we probably just all do our sense together. Right? Where did we lose you guys? I'm not reading the chat. Open your message.
The young lady that responded just a while ago, her response was actually spot on to what he was asking. So I'm not sure if maybe she wants to run that over again, because it was actually a very good response.
I agree.
Miss, I'm still confused, Miss.
Sarah, can you come on and explain to us again, please? Is it Sarah? I don't remember who said it. Was it Sarah?
Yes, please.
Can you respond?
So basically, the equitable right to redeem, if it benefits the mortgagee in terms of, yes, the equitable right of redeeming the mortgage, drawer has the right to owe whatever debts and so forth that they owe the bank. But if it gets the bank or the institution, sorry, but if it gets out of control, like say for example, you missed mortgage payments for 2 months, you will still have the equitable right to redeem. But if it goes after 6 or 7 months, the bank basically has the right, or the institution has the right, to take away the thing of value away from you.
Okay.
Okay. Miss, I think I understand now, Miss. So basically, she's saying that after the period or the time frame in which the equity of redemption was valid, the bank then takes away the collateral.
Hallelujah. Praise the Lord. God is alive and well.
So
that's it.
Okay,
Can I ask a question, please?
Who is that?
I'm asking a question.
Go ahead, Renee.
Okay. So I'm not misinterpreting what Sarah is saying, but in Jamaica, we have a thing where the financial institution cannot actually take away any like chattel within your home or anything to say that, oh, it's collateral. The only way that they can actually not redeem, they can take your property after not paying is just taking the land itself or what, and that's it. But they don't get to come in and take up your bed or your TV and say, okay, we're gonna use it as collateral.
I think I'm happy that you pointed out, but I think it was already established that they can't take furniture and stuff like that. They can only claim collateral from that which they agreed that would be collateral. So if it's like you rightly said in Jamaica, if it is that it's a house, and that's why when foreclosure happens, they are only able to take that which they agreed. So if after 10 years the house is now valued at 65 million, they can only sell the house for the 35 million that they agreed to. Okay? Am I clear?
Right.
And
So you cannot overprice the house because you're now the one selling it.
No,
Right.
that's why people always look to buy foreclosure properties, because it's so cheaper, or it's
Yes.
sold at the very same value at which it was at the time that the agreement was
Okay,
entered.
thank you.
No problemo. Trent, you were saying something?
Yeah, I was gonna add something, but I say I'm not gonna confuse y'all any further. But I was just gonna say
I beg you do.
Yes,
no,
please.
I don't think it could confuse you all, but she was saying that they can't take any shuttle, but foreclosure is a right outside of the courts, so they could only claim what is under the agreement. But if the financial institution goes to court and says that you owe them X amount of money, then the court could direct that they take certain, as you said, shuttles as collateral to fulfill the debt. So if you have a vehicle, if you have something else, they could actually take those particular assets to fulfill the debt. But you don't have to confuse yourself. Foreclosure, they could only take what is under the agreement to satisfy the debt.
And And Cape is not going to complicate it like that and ask about all them other things. And no, it's not going to be like that. You're not in year 3 of faculty. It ain't going to be like that. Trust and believe. Don't overcomplicate it. You guys are bottom line lost. No, and let me not disrespect y'all like that. Y'all, well, it is what it is. You guys are at the bottom of the food chain as it relates to law, right? Ain't nobody expects y'all to be no judge, jury, and executor. Just answer the question that is being asked. Stop overcomplicating it. Wondering if I'm going to get to year 1 of faculty. Listen, we're not putting that energy out there. We ain't putting that out there. But yeah. Akil, I'm going to remove it from this chat. And let's move on to the other questions. Can somebody else proceed to read for me? And we never heard decided cases all no. So I guess y'all gonna be like in a decided case, like a student who don't read.
Well, Miss, let's not focus on that, Miss. Let me just read it. In the event that the mortgagor repays the loan and interest on the 30th day of April 2023, the house and land located at West Tres, St. James will no longer be held as...
Start over again, sir. Or you reach down there, so start at C. The mortgage deed between Easy Lending Mortgage.
The mortgage deed between Easy Lending Mortgage Company and Horton stated as follows. In the event that the mortgagor repays the loan and interest on the 30th of April 2023, the house and the land located at West Tres, St. James will no longer be held as the security for the mortgage. Horton failed to repay the loan and the interest on April 30th, 2023. Advised Horton using the common law and the equity as to whether he would lose his property since he did not repay the loan and interest on the date. Use one-sided case to support each of your answers. And they can match this up now.
We, you. Come on.
Oh.
What is the question asking of you?
It
Advice,
says
Horton, please. What's the advice?
Wants us to use common law and equity. So, Miss, I know there's the right to the equity of redemption, yes? That. Passing the torch to somebody else.
But you don't start much as a pass. We've been passing the torch. You have yet to start. You only read the question and said, yeah, equitable, and yeah, no. What's your response to the question? What are you advising?
Okay, Miss. So we're advising whether or not Horton would lose the property since he did not repay the loan and the interest on that date.
I see.
Guys, don't allow the question to trick you. The question, this question is literally discussing the last thing we spoke about. This redemption, what did common law say? The common law say if you don't pay, you lose it. Equity come and say it's too hard, so now let's show you softness up. This is what equity say. It's literally the last thing we spoke about.
Okay. So okay. So all right, let me go again. So it is saying that the equity of redemption on the mortgager's side, it's basically stating that if the mortgage... Hold on. I need that break.
First, think about it. I need y'all to get probably a paper and a pen and map it out. what does the common law say about failure to repay your loan and failure to repay your loan and the interest on the specific date? What does common law say? Right? Having established what common law says if you don't pay, like Keandre says, if you don't pay your loan, the mortgagee has the right to come and reclaim the property, right? But then, like Keandre said, and like Trent said, and we have been preaching like Paul to the apostles and to the Gentiles, right? The equity says that no, this is too harsh. There must be another way that we can soften the blow where both parties can feel like they got something out of the deal, right? Equity is here to do what? What is first of all, what is equity? Let's start there.
Miss it wants a bit to miss it wants it wants it to be fair between both parties.
Okay, but what is equity, law students? What is equity?
Equity is basically that a person should not benefit from unconscionable actions, miss.
Okay.
So because common law is too strict, equity is kind of like a little exception to common law.
Like somebody posted in the chat, it's kind of to ease the harshness of the common, right? Equity treats everybody fairly, right? And when you guys reach further in law, you will learn about the maxims of equity and all these other things, right? But equity is here like I feel sorry for you. And so we're gonna find a way to embarrass you, but not really embarrass you, right? So common law is like it is what it is, the blunt brother. Equity is the soft sister, like, okay, let me hush you. But you still have to go pay back the people them loan, but we're not gonna just come and just take the property like that from you. So what you guys need to first establish is what does common law say on this issue and what does equity say on this issue? And then give your advice. Because it says Horton failed to repay the loan and interest on the 30th of April. Advise Horton using one, advise him what is going to happen at common law, and also advise him what would possibly happen at equity as to whether he would lose his properties since he did not repay the loan and the interest on the date. Use a decided case to answer your support your answers, right? Explain to the general what is going to happen at common law and what exactly does equity say. Tell the man if he will lose his property or not. Will he lose the property? Will Horton lose the property?
No,
No. Why?
because equity is able to mitigate whatever common law is deeming as flexible, although it is inflexible. So equity will step in and let it be known that once a mortgage, it's gonna remain a mortgage. So regardless of not following whatever formalities was created at first, there will come equity where not because of missing a few hours or a few days means that okay, you're not gonna have any more right to your property. Once you clear the loan, you're gonna be able to redeem what was yours.
Miss, may I say something, please?
Go ahead.
Miss, the question asks that you should advise them using common law and equity. So how I would approach this question is I would say that under common law, basic being that common law is strict, he would lose the property. And then after explaining whatever, then under equity, I would say that he wouldn't lose the property, if you get what I'm saying.
I don't get what you're saying. Tell me what you're saying. And don't say something. I can't fill in the blank. I don't know what you're talking about. I don't learn this topic before. Explain to me. You're writing the exam.
So
how would you answer the question?
Okay. So I would advise him that I talk about what common law says about
What does common law say?
Common law says that if the mortgagor fails to repay the mortgage from the by the date stated by the mortgagee, then the mortgagee has the right to basically foreclose the property. or take back the property for so they can, so because the property is basically collateral, so they take it back for the repayment of the loan. So under common law, because he couldn't repay the loan, he would lose the property. However, now equity is, as she said, the flexible equity in a sense, it, because common law is so strict, they came about with equity, and um equity in of itself, it's basically an alternative to the harshness of common law. So it takes into consideration the fact that, oh, you would have already been making payments, so they're going to make some arrangement for you to not lose the property, but however, you still would have to repay the amount left for the mortgage.
Okay, so are you saying that at equity, they won't lose the property? That's what you're saying.
Yes.
Don't say outright that you won't lose the property. But you're on the right track, I would say. You answered before. I think you guys answered very well. So what she said before in terms of the equitable position complements your common law position. So you said that once the money is not paid, as you said, in short, once the money is not paid to the mortgagee could foreclose on the property to receive funds owed to them. Equity steps in to say that even if the contractual date has passed for you to repay your mortgage and you still have not repaid it, you have an opportunity to make good on your debts. However, that doesn't mean that you just not lose your property. You could still, but you just have a little leeway, you have a little extra time now to pay your debts. So that's the equitable position.
Okay, understood.
And then to top your answer off, you should also use the legal term. So I remember when I got in, Trent was discussing the right of redemption. Now that's something you want to put in your answer to actually make the examiner know that I have read, and this is what this is. Because this question really asks you about the right of redemption. If you could show the examiner right off from the bat that I know we're speaking about the right of redemption, and you go on to explain, there's no reason why you can't get your full 15.
The clear difference between a grade 1 and a grade 2. Clear difference. Stop using regular terms that somebody outside would could be using. You guys are law students. They expect you to speak from an informed perspective using proper legal terminologies.
Exactly. So this question is really just asking you to explain, in number one, the legal right to redeem, as I just explained. The second one is the equitable right to redeem, which is what the young lady explained previously. So don't overcomplicate it. They might use different terms and different jargons to try to throw you all off, but just think about what they're asking you. It's not hard, trust. You'll
It's not hard.
see.
It's gonna be hard if anybody that read and you're not prepared.
Yeah. Once you
But
prepare,
you are prepared.
yeah, anything they throw at you, you could just decipher it. Because the knowledge is there. So once you know what you know, rely on what you know. Don't think it's something else, because then I'll ask you a question you didn't learn.
Exactly.
And I'm hoping that after we answer this question that the difference between both is clear. And the truth is, this is, in my estimation, one of the few ways that CAPE could test you on mortgages. They're going to expect you to know the difference between what happens at common law and what happens at equity. Because apart from, as you see above, define this, define that, there's not really anything else that they could really ask you. So the nitty-gritty of mortgages really come down to this right of redemption, causing the right of redemption, and these type of.
We're getting it?
Yes,
Are we on the
miss.
same page?
Yes, miss, I'm getting it.
All right, I see Akil is very much back with us. Go ahead, I see your hand raised, my darling. Go ahead.
All right, yes, miss. So basically, what I was saying would be advising Horton on the equity. So the case that would be instructive here would be Samuel and Jara Timber and Wood Paving Corporation, where it was held that terms that are at odds with a mortgage and are favorable towards the mortgagee are generally void. So in this case, the term stipulating that Horton would not be able to pay after the 30th of April, considering that it's only favorable to the mortgagee, then equity would consider it void and basically give Horton an opportunity to actually repay the loan.
Good. Okay. So nobody knows no cases, y'all just go on vibes.
We just say a case.
No, not you, darling. I'm talking about everybody else. I never heard mention of a case. Well, cases, and it says you're supposed to use how many cases? At least one. So, listen, I think y'all need to, at least that's what we were taught. Well, we weren't taught this, but eventually once you go through the system, you realize, try to remember, put your topics down. You have mortgage, try to find 2 cases on the mortgage. You have contract on the offer, try to find 2 cases on the acceptance, try to find 2 cases on the performance, try to find 2 cases for real pop, try to find for landlord and tenant joint tenancy, find 2 cases that will work, and then find a way to remember your cases, right? Like the Donahue Stevenson case in negligence, remember it by saying, okay, I remember the snail case. Yeah, the snail case is that. You have cases from criminal law that you will remember forever. Jordan and R, and all these cases, Hyde and whatever, Hyde and or whatever, the crown. All these cases, you remember them because of what they're attached to, right? So find a way to remember your cases. Gone were the days when you could be in a decided case. Ain't nobody got time to be trying to figure out what the decided case was, right? A sociology student could say in a decided case. A math student could say in a decided case. What makes you a law student? You have to know the law. You have to know your references. You speak from an informed perspective. And that is what will separate you from a grade 2 and a grade 3 to a grade 1 all A profile. Right? And you guys are all capable of getting it. You just have to commit the time, put in the work. You have 3 days till the exam. Go all in. Read all you can. Go through your slides. Go through past paper questions. Ask relevant questions. Perplex your teacher. Ask your questions. Ask your classmates for clarity if you know they're strong in a particular area. But read your cases, read your notes. Anybody else want to make an attempt at this question?
Samoya, I feel personally this question. I feel mortgages get enough time.
I find it's 9:06. All right, quickly, what else you guys don't understand? We all have mortgages now.
Miss contracts.
Contracts.
What on the contracts?
What's on the contract? Because ain't nobody going to go through contract. Contract is a very long road to Jerusalem. What's on the contract? Easement. I figured.
Yes, miss, that.
Easement on the contract?
Easement on the property that.
Easement is real property. Yes, y'all have some studying to do.
Property. Y'all got some work to do. What's under what is module 2, by the way?
What?
Contracts.
Contract. What under contract?
Privity of contracts.
Privity.
Offer and acceptance.
Intentions to create
Contract.
termination.
Alright, I'm gonna need y'all to drop that in the chat. I see frustration, leases and lies. A, contract, not real property yet. Contract. Frustration, privity of contract. Trent, you want to hurry and Keandre?
Terms of a contract.
Frustration is very easy, I believe, to understand. I think the most complex of these topics that you guys are talking about here would probably be probably the privity, but and you guys want to touch on frustration? Frustration is really an essence of what the word is.
Well, just to give a short definition of privity, privity is just to say if a contract is made between A and B, then C cannot acquire any legal rights under the contract. Only A and B, the parties under the contract, could acquire any legal rights. So they could sue for any breach of contract. They could sue for any condition that was not performed, and so on.
So basically it's privacy.
Yeah, if you want to remember it, that is basically.
Remember it like that.
But don't put that on the example.
Yeah, exactly. Don't do that.
But privity is basically to say, as I said before, two or more parties have a contract between them, or the parties outside of the contract cannot acquire any legal rights. So if a mother and her husband have a contract between themselves to do certain things, the child cannot enter to say, just because I'm the child, I have rights under this contract, because it was between those two persons alone. Of course, there are different scenarios, like delivery services that might be a bit different, because that means there's a third party who is also a part of the contract to transport things, like a middleman. So only where there's a middleman, then that's an exception really to privity. So delivery services, like the shipments, when you order something from Amazon, of course, you and Amazon have a contract, and then FedEx would be the third party who also is a part of that contract.
Beautifully explained. Everybody got that?
Yes, miss, I understand that. And that's under privity.
Yes.
In a nutshell, of course, they have more detailed stuff I think y'all should know.
Yeah, details of y'all should know. Next, let's see on frustration. Anybody have a question on privity? Any more questions on privity? Going once, going twice. Moving on. So the doctrine of frustration in contract, like the word suggests, in essence, occurs when unforeseen events fundamentally changes the nature of the contractual obligation, right? Making it impossible to fulfill or to actually fulfill the contract as it was previously drafted or whatever, right? So for instance, if it is having a wedding and you hire me as a wedding planner and not a wedding planner, and the caterer for the event, right? And unfortunately, hurricane come, cause power outages and fire in my place, and my kitchen burned down, and I'm unable to fulfill the contractual duty that I had to actually provide the catering to your wedding. That is a situation where the contract is frustrated. We got that?
Yes, miss. So frustration relates to the contract not being able to be completed.
Yes, you're not
For
able
whatever
to
reason.
carry out your contractual duty because of unforeseen, use legal, the terms, the proper terms, unforeseen events that fundamentally changes the nature of the contractual obligation.
Yes, that's true. So the point of saying unforeseen here is because you cannot have frustration if the event that is purportedly causing the frustration is caused by either of the parties. So you can frustrate a contract and then claim frustration. It has to be something that happens without the default or the input of either of the parties.
Exactly. And the impossibility and illegality is important too. That means that the event must render the performance of the contract impossible, illegal, or impracticable, right? It renders the performance of the contract to be impossible, illegal, or impracticable, right? We get that?
No, miss. Could you repeat what you said, please, miss?
Sorry, I'm gonna go slower. Impossibility or illegality, right, are one of the key elements of frustration. I think there are three, if I'm not mistaken. Trent and Keandre can correct me. I think there are three key elements of frustration. I think it's unforeseen events, radical change, or impossibility or illegality. But impossibility or illegality is the event must render the performance of the contract impossible, illegal, or impracticable. It means it cannot happen. Impossible roadblock, hurricane come, island-wide power outage. No one can keep, I can't cater, I don't have no kitchen. Right? It cannot be by a breach. A breach would be that a party would have to, like Keandre said, unforeseen event cannot be due to the fault of either party. And for there to be a breach, there has to be a fault by a party. Are you guys getting it?
Yes, miss.
Just a point.
Miss, cool.
Sarah? Sarah, are you getting me? Okay, Sarah's not responding. Unforeseen event, like Keandre said, it cannot be due to the fault of either party. The event must be unforeseen and not due to the fault of either party. Right? The radical change must be a situation where the event must alter the nature of the contractual obligation. So significantly, how do I put it? So significantly, well, it affects the very nature, or alters the very nature of the contractual obligation so significantly that it would be unjust to hold the parties to the original terms of the contract. Right? So it can't be a case where the caterer is unable to perform the duty because a kitchen burned down or a restaurant burned down, right? You can't expect the lady to go out at the seaside, go catch coal to provide the food for the party, right? Natural disasters, yes. You cannot expect them to be for them to be held at the same standard as the original terms of the contract when the very nature of the contractual obligations were significantly altered. Right? If the woman in a one coma, you can't get up. Like you said, what about illness? The lady, your caterer can't go into a coma and she alone the cooking in the kitchen and she go into a coma. And then 2 days after, you're going to sue the lady when she wake up because she's going to a coma and never provide catering for your event. No, that's not how it works. that is a contract, the very nature of the contractual obligation were significantly adjusted, and it would be unjust to hold the party to the original terms of the contract. We get that? Are we with me? Perfect.
I have a question.
Go right ahead.
When she was talking about she asked in the chat if it was illness. Isn't it not any illness that could frustrate a contract? It depends on the person, like if they occasionally ill or they won't be able to perform for a certain amount of time.
To answer that question, right, as it pertains to illness, think of frustration as somebody not being able to perform their contractual obligation. So if it is that you are sick in the time that you would have been expected to, as the example Samoya was using, cook some food, you cannot carry out those duties. And illness is not something that you can predict. It just happens. So frustration really occurs like where one party cannot fulfill their obligation under the contract, and it is not because of anything that they did. So for example, a fire, hurricane, like Samoya said, if you're getting a coma, you simply cannot perform your tasks, the tasks that were required of you, and it's not something that you did to induce it. So let's say, for example, then using the same cooking example, that and let's try to use sickness as well. So let's look at, let's say, I know I am lactose intolerant, for example. And because I know I have a contract to cook tomorrow, I willfully go and consume, let's say, milk. Then that might be something different because I did something to induce myself to not be able to perform the contract. But if I did nothing and I just get sick, I really can't get up and cook for you, then that's different because it's not something that I caused.
Okay, thanks.
I think you guys should look at the cases too, because there are a lot of frustration cases that would help you understand and see it better.
Undecided cases, Trent.
Huh?
You know, read cases that are say undecided cases.
Well, you can't do that. There's a lot of cases that you guys could look at for sure. To see frustration. Because just thinking about it, the concept in itself might be a bit difficult. So once you read the cases and you see the facts, that would help.
I see a hand up. Is it an old hand or a new hand? And if it's a new hand, feel free to go ahead. Sarah?
So basically, under sickness, I have read this case that it says like sickness can be under frustration, but it depends on the circumstances. For example, there was a pianist that was supposed to like perform, but because they got sick, they were unable to carry out their contractual duty. So that was a case under frustration. But the person also noted that it depends on the circumstances. So if you know that you're a person that you have a specific occupation to carry out a contractual agreement and you get sick and you're unable to do that, then it could be valid. But in not all situations, when in terms of being sick, can that work?
Yes, that's actually correct. I remember that case too. And I think that basically goes back to well, what we've been saying tonight. It depends on this in terms of illness, it really depends on the situation. If it's something that is induced, like you induce yourself, then you can't frustrate something and then claim that it was frustrated, so you can't do it. But if it just happens, then it happens, and then you could possibly use the defense of frustration. And like Trent said, you really have to go and read the case. If you don't quite understand the concept that we are trying to explain to you, the best thing for you to do is actually to read the case. All in all, frustration, like we said, really occurs where one party is not able to carry out their obligations, and you are not able to carry out these obligations not because of something that you did, but because of something that naturally happened.
Alrighty, so everybody's clear on that. Which other topic you guys had mentioned? No, you said terms of contract now. Let me tell you something about these terms of contract now that y'all gonna get me a little upset about. You guys should know and have. There's no way you can understand any other topic on the contract if you don't understand the terms of a contract. What are the terms of a contract, students?
Conditions, warranties, innominate.
And then I heard the last one.
Innominate.
Is she correct, everyone?
Yes.
Okay. What exactly don't you guys understand about these things? You guys want us to give you definitions of these terms? Come on, talk quickly. It's 9:27. I have school in the morning. Hello? Did somebody say that for me? That cannot be the question that you're answering under here. Hello?
Yes, miss.
Those are not the only terms of the contract.
No.
What are the other terms? You said conditions, you said warranties, innominate terms. There are two others that are very popular, way more popular than the ones that you guys have. They're important, the most important ones, but we have two other ones. What was that? Who answered? Is that me?
Alternate.
Alternate. Express and implied terms, guys. Express and implied terms. Never heard those before? Because they're very much on your syllabus.
I'm not sure if you weren't hearing.
No, your connection is not the best, so I'm just hearing in and out. So if you said it, my apologies. What are implied terms of a contract?
Miss are those terms that aren't stated but are subject.
Those terms that are what?
Miss, I said aren't those the terms that aren't stated but
Alright, your connection is not well. I heard those are the terms that are not stated but are, and you just cut out on my end. Not sure if everybody else heard. Shanine? That's the name? Go ahead.
Yes, that's the name. So implied terms are essentially terms that aren't, these don't have to be expressly stated. it is essentially a customer. For example, a person going into a restaurant and they order their food, an implied contract is created because the restaurant is not obligated to serve that person food, and the person is not obligated to pay without it having to be expressly stated.
Okay.
That was the explanation for innominate terms?
That was implied terms.
Implied. Okay. Okay, I just look at my phone for a second. All right.
Basic definition for implied terms, they're not explicitly stated but are inferred by the courts or statute to fill in gaps or ensure fairness, right? I don't know what's a good example. Kendra Trent, what would be a very good example that they remember for implied terms? That restaurant would work.
I think I was
The
gonna say
restaurant would work.
that was a fine example because
Yeah, the restaurant could work.
regular transactions, day-to-day transactions would be implied because there's no contractual agreement to say you must pay this person, but obviously you can't pick up something in a store and walk out with it.
Exactly.
So it would be implied that you pay money for a certain thing, consideration. So I can't really think of another example of an implied term.
All right, so we can use an example. What are express terms?
They are explicitly stated.
Okay, you want to give me an example of that?
Before we go on to express terms as well, I think one of the things that they should note for implied terms is that implied terms can be categorized under three categories. It could be implied in fact, by law, or by custom or usage. That's something that your teacher should have taught you guys. I'm not necessarily going to go into those specifically, but those are just things that you should know. If you don't know, then you should probably get to know them.
Exactly.
Yeah, and then you can go on to express terms also.
Can I have an example of an expressed term?
The date by which the contract is to be fulfilled.
Okay. Anything else?
If money is involved, the amount.
That is to be paid. Okay, so price. So express terms, because we need to wrap up this session and you guys are taking further. Express terms come in categories of price, payment, amount or payment terms, specific obligations that each party is expected to carry out. Right? We good? We got that? Hello? Please pay attention to the chat because Keandre typed what he was saying in the chat, so you guys would, if I were you, take down that information. We got what the express terms and implied terms?
Yes, ma'am.
Yes, Samoya. The mom. Alrighty. Can someone express to me or explain to me what are conditions? Conditions.
The basis on which the contract exists.
Whoever's talking right now, I need another answer here because I need to know if everybody else is getting it. Appreciate you for being on par though. Anybody else? I'm gonna start calling some names. Cherise, Danielle, Renee, Amy, Kayla, Sean, Tony. You guys wanna step in?
If that's okay.
Go ahead.
So it's like important, it's critical to the contract. And if a term is breached, if a term is breached, the injured party, they could seek redress or they could rescind the contract. Now, a term goes to the roots of the contract. It's fundamental. And the breach of a condition could entitle the victim to rescind, or he could pay in damages.
Okay, will you remember that definition in the exam?
Yes, I think so, yes.
Okay, give me an example of condition.
Okay, hold on, let me think.
Anybody else?
To add to, I don't know who spoke first, but an example is where you pay for a ticket to an entertainment thing, and you have to get the artist has to sing there, and that's the whole reason why you enter into the contract in the first place, because you wanted to see that artist. And if he's not present, then you're able to go back and get back whatever you placed or filed for, or you can get back your money because you did not get what you actually paid for. You actually went into the contract for.
I don't know if I necessarily like that example, because I think that in itself is a little more complex than it sounds. I don't know if Kianji think it's okay, but I don't necessarily like the example. Kianji, how you feel about it?
Hi, sorry about that. I was responding to some messages in the chat. Can you repeat that for me, please? Sorry.
Just giving an example about going to an event, and the main purpose of her going was to see an artist perform, and if they don't perform, they will breach a condition of the contract. And so she has the right to claim. But I'm saying for me, I think that I don't necessarily like the exam because I think it's way more technical than just, a mere claim in under those circumstances.
Yes, I agree, because generally, as it pertains to concerts, right? Unless that person is, let's say, it's a sole concert for that person, it does not necessarily apply, because what you pay for is a concert. So you can have a concert, for example, with, let's say, 5 different artists, but you really want to go and see one, and that one doesn't. But that doesn't mean that you did not get a concert, if you understand what I mean.
Exactly. I agree. Kayla.
So I have one. Say for instance, you rented an Airbnb to again go to a concert and the concert got canceled and you don't have any other reason to go to stay at the Airbnb because you don't have anything else to do. Wouldn't you be obligated to receive back your money?
No.
Or not?
No.
Okay.
That's a flat no. Ain't nobody told you to rent no Airbnb. That's not the fun. That's not the concert planner's responsibility if you rent that Airbnb. No. A very basic example is the sale of a car, right? So in a contract for a sale of a car, the term that the car is roadworthy, is it in roadworthy condition, is a condition. It can't be on the road unless it is in roadworthy condition. That is the condition for the sale of the car. Right? Kayla, is that a new hand or an old hand?
That's a new hand. So
Go
like
ahead.
the color of a car could be a condition, right? or the
Like,
brand?
you're saying that if you wanted to purchase a blue car, you get a black car, you're gonna breach a condition.
Yeah, like if I say, okay, I want to purchase a blue and I specify the brand, like a Kia, would that be considered a condition?
If, if that is your condition, I would think it would be a condition. Keandre?
Yes, your condition is basically a term that is considered to be critical to the contract. So if I go and let's say I want a four-seater vehicle, no, let's say six, and you come back and you say, well, I can't really give you the six, but here's a four. That would be a breach of one of the conditions of the contract, because it goes basically to the root of what you wanted. So when you think about conditions, think about things that go to the core of what you wanted. So for example, somebody asked about the Airbnb before you rented the Airbnb. As the person who rented the Airbnb to you, my sole purpose for renting that to you was for you to have a place to stay. I don't care if it is that when you came, the reason why you came does not happen anymore, unless our contract says that I am renting you this Airbnb in the inclination that XYZ is going to happen. So if I'm saying, for example, then let's use airports. Let's use American airports. You land on an American airport, they generally have hotels. So let's say the Marriott example is on one of the airports that you land at. And you book a room at the Marriott, and you say to these people, okay, well, I am only staying at your place if my connecting flight would be, let's say, leaving from this airport, right? If it is that when you get to that airport and your connecting flight, in fact, leaves from another airport, then that is a breach of a condition, because it goes to the core of the contract. The core of the root of the contract was really that I'm renting this place for this purpose. If this purpose cannot be fulfilled, then you have breached something that was at the root of the contract.
Okay, thank you. Understood.
Alrighty, guys, it's 9:40. Myself and Keandre we have work in the morning. And I find that we have touched on majority of the topics. Everything else, I find that you guys, with reading and brushing up on some areas, you guys should be fine. We open the floor for just one more question. I would really like to go all night with y'all. No, that's not true. That's not true. I like to sleep. But if it is that you guys have any other further questions, feel free to message me. I'm going to be sending a message in the main chat now so that you guys can have my contact. Feel free to shoot me a message or give me a call. I am a teacher. I teach from the hours of 8 o'clock to 2:30, so you guys can contact me anytime after 2:30, right? And no later than 8 o'clock p.m. Right? Feel free to reach out. I hope that this session was informative for you all. I wish you guys all the very best. Thank you, Keandre, for joining me, friend. I appreciate you. And we wish you guys all the best. I'm not sure if Keandre has anything else to add.
Yes, thanks for having me, Samoya. Like Samoya said, I wish you guys all the best in the exam. I saw earlier, and maybe we should end by answering this question. Earlier in this session, somebody asked about tips to prepare for the exams, and I think at this point, with the exam being 3 years away, the only tip we can really give to you guys is for you to really go and read the material. What you can do, like Samoya said, is to get cases for each topic. So for example, we spoke about discharge of contract when we spoke about frustration. So you would go and write on the frustration, your heading is discharge. You could put A, frustration, you list 2 cases under there. You might want to write maybe like one line of the facts that make you that help you to remember what the case is. So if you want to remember it as let's say hurricane happened and you know for sure, okay, once you read the case and you're gonna remember what the facts were, what happened when the hurricane happened, then you can do that. And what the holding of the case. Once you do that, then you should be fine. Now, those are the only tips I would be able to help right now because they're really practical. If it is that it was at the beginning of the semester per se, then the tips would have been different. But now that you're crunching down to exam time, those are the main 2 tips that would really help you. Apart from that, all the best in the exam on 3 days from now. And yeah.
Alrighty, thank you, Keandre. I wish you guys all the best. The recording can be found on the New Jamaica Foundation page that will be published on YouTube. Not sure when it will be uploaded, but it should be uploaded sometime soon. Feel free to reach out. I wish you guys all the best and have a very good night. Bye-bye.
Good night.
Thank you, guys.
No problem.
Good night. Thank you.